Hey there, Chapter 6, Part 9. Here we go. Okay, where we left things off in Chapter 8, we were about to get to something that's quite famous in the application of economics to the law, and that is something called the hand rule. I'm going to get to that in just a second, but a reasonable question to ask is, if both parties get injured in an accident, can they sue each other? Of course they're going to sue each other. That's going to be cross complaints, which one sues one party, the second party sues the first party. That's a pretty common thing. And the question is what is efficient in a single accident relevant when we're looking at what we call bilateral harm? And the answer is yes, because in each case, we could look and see whether that each individual party was in fact negligent. And to look at that, we bring ourselves back all the way, I think, to the 1940s, to the hand rule, which is also known as the calculus of negligence, zooming in on the benefits from precaution, the costs associated with precaution, all of the stuff that we talked about with our big diagram, that one, that you may recall, that focused on the optimal amount of precaution, which is going to be right there. That's going to minimize the costs, as you recall, and that is shown by the solid lines. And this analysis comes from a judge by the name of Learned Hand, Learned, one of the greatest names ever. And what he did is he kind of simplified what our analysis is, but he's really just restating it. And that is, you may recall, as long as the marginal cost, remember W was the cost of precaution, the marginal cost is less than the marginal benefits, which takes into account the change in the probability of an accident times A, which is the damages. If the marginal costs are shown to be less than the marginal benefits, and the party did not take more precaution at that point, or they really should have taken more precaution at that point, then they would be found to be negligent. Okay. So what he did is he came up with these three terms, B, P, and L. B is simply going to be the cost associated with the precaution. P is the change in the probability of the harm. L is the loss. It's the same as A that we talked about here. So we have a question at the end of the chapter that's going to address that very issue. Okay. Now we know there's a lot of different standards here with respect to tort liability, and the question is, for whom does taking precaution make sense within the particular context of the event that we are looking at? So if it's a negligence rule, there's obviously incentives for both parties to take precaution, the victim and the injurer. With strict liability, only the injurer is taking precaution, and with no liability, only the victim is taking precaution. Okay. So bear that in mind in terms of thinking of the situation and what does it make sense to do? Should the onus of being careful fall on both parties, or is one party at a distinct disadvantage because the actions of the other party will typically drive whether or not an accident occurs? Okay. And now we can turn to consumer goods, because consumer goods are a perfect example of how the law has evolved, and it's evolved in a way that kind of makes sense. And that is, we have evolved towards strict liability for consumer goods. Yes, there is going to be a defense of contributory negligence when somebody uses a product in a manner that is clearly not prescribed. The Fabergé case that I talked about kind of deals with that issue, but it is very difficult to prove that a product was negligently manufactured. So the presumption is, if the product fails, it's failing because of the liability of the manufacturer as opposed to how someone is using it. Again, unless they're shown to be using it in a wholly inappropriate manner. Okay, so if we focus then on negligent manufacture of a product, then all you have to do with strict liability here with these consumer goods is to prove causation. You don't have to prove the third element of the tort. And manufacturers quite rationally will take precaution. That's why manufacturers will frequently recall products, even if there's, and they tend to err on the side of caution. If there's someone gets sick from something or glass is found in a product, there'll typically be a pretty significant recall of the product. And that is why if you look at manufactured goods, look at a can of food, for example, there will be all sorts of codes on there, and that enables the manufacturer to kind of pinpoint exactly which products to recall, because it would be around the time frame of the product that was that failed. Okay, that some sort of product was found in. Okay, so question to ask. We're going to change gears for just a second, then we're going to come back to consumer products, and that is, what do you do if awards are not right? Okay. And you could read the passages in the book that kind of deal with that. I don't want to get into tremendous detail with it. But with strict liability, you know that there's deficient precaution, certainly on the part of the victim, because there's no incentive to take precaution. How about on the part of the injurer? Okay. That depends upon whether jury awards are found to be consistently too low or too high. If they're too low, then even though I'm the manufacturer of the product and I'm going to be on the hook, if I know that the awards are not going to be that great, I'm not going to take much precaution. That's an issue that comes up with regards to medical malpractice, because if the damage awards are capped and the non-economic damage awards are capped to $250,000, then the upper bound of losses in most of these cases are going to be really constrained, and that's one of the concerns expressed about the cap being where it is. Legislatively, we have not seen a movement in that cap for more than 40 years, so it's kind of a difficult one to get over. Okay. So, does an error in an award, meaning like what if juries are really conservative, and obviously the opposite effect if they tend to be really liberal, and we talked about that earlier in the chapter. There's a diagram on page 219 that's actually relevant for this discussion, and that shows you here, I think B is the one, but it doesn't matter if it's B or C. But let's assume it's B is the right one for, or even A is the right one that then goes along after the efficient level of precaution here. So this is the first part of the expected social cost, and this is going to be the second part. What this diagram shows, and it's kind of interesting, is you can make a lot of mistakes, but as long as you're not undervaluing the loss to such an extreme that it leads you to curve D, it's not going to affect the level of precaution. Whether you're at A, B, or C, all of these at X with the tilde sign are below this point, which represents the official level of precaution and then the cost of precaution only. So you're going to be in the permitted zone here, even under A, B, and C. With D, that leads you to too little precaution because you think like, the harm's not that great, so I don't have to take much precaution into account. And if the jury awards tend to really, really lowball the damages, then in fact you will lead to too little precaution. Okay, it's not perfect. We understand that. Okay, next thing that I want to turn to is an application of consumer products, and that is the following: when you use a good, there's a risk associated with it. Okay, You use a bottle, the bottle could break in your hands. You use a can, you could cut yourself on the can, and the like. So what is the efficient thing to do? And there's a nice little example that is illustrated on page 225 of the book. It's kind of a famous one, and I want to talk about that. So we have a product here where you can think of it like soda. It can be produced in a bottle. It could be produced in a can. Bottles are cheaper to produce, but if a bottle fails, you're more likely to suffer a more serious injury than if you use a can. Okay, so here's the deal. Okay, we can lay out here what the firm chooses to do, a bottle or a can, the production cost only, we're not considering any harm to anyone who might use it and the product fails, is 40 cents for the bottle, 43 cents for the can. So under a rule of no liability, we're done. The bottles are cheaper to produce because, it's up to the user, and the manufacturer takes no responsibility if somebody gets harmed. Okay. Now we take into account the chance of getting hurt. 1 out of 100,000 with the bottle, 1 out of 200,000 with the can. Bottle's more likely to crack and break than a can is going to fail. The loss associated with the bottle failing is $10,000. With the can, the injury is only $4,000. That kind of makes sense. Again, the bottle explodes in your hand. That's the famous Escola v. Coca-Cola case. Then you can get stitches and cuts and stuff like that. That likely are more serious than if you simply cut yourself on the edge of a can. The expected loss takes into account the probability of the accident occurring and the damages. Just multiply them together. It's going to be 10 cents per bottle, 10,000 over 100,000. But it's only going to be 2 cents per can, 4,000 over 200,000. When we add the expected loss from failure to the production cost, then the true total cost is going to be what? 50 cents for the bottle and only 45 cents for the can. So under strict liability, the can is the cheaper thing. Under no liability, the bottle is the cheaper thing. And so it's a question of whether or not, what is the right law to have? What is the right rule to have? Well, are consumers well-informed or not? If they're well-informed, clearly they're going to use cans because it's going to be cheaper. If they're imperfectly informed, they're going to use whatever product is less expensive on the shelf, and that's going to be the bottle, okay? So we usually look, in a case with imperfect information, strict liability kind of makes more sense. Hold the manufacturer liable, and then the price of risk will be included in the price of the product because the manufacturer is going to be on the hook for that. Okay, next part, we're going to deal with the questions that we haven't covered at the end of the chapter.